Hey everybody, my name is Jasmine Barber, and I am a bar license attorney in the state of Georgia, practicing primarily criminal defense. And I posted on Facebook that I believe Derek Chauvin should be charged with first-degree murder, and I have a lot of reasons that I want to explain that to you guys. But before I get into my reasons why Derek Chauvin should be charged with first-degree murder, let me give you guys a few very brief, very quick disclaimers. The first thing is that I am not licensed to practice law in the state of Minnesota. I have done some legal research. I believe I have a decent grip on the area of law in the state of Minnesota, but I am not a practicing attorney in Minnesota. Second, I'm a criminal defense attorney. Very rarely do I take a stance that someone should be charged with a higher degree of any particular crime. As a defense attorney, I typically am arguing the mitigating factors in order to bring it down from a first-degree murder to a third-degree murder charge. But particularly in the case of the killing of George Floyd, I feel it prudent to offer at least a little bit of legal discourse on why he could be charged with first-degree murder. Derek Chauvin could be charged with first-degree murder based on my reading of the statutes in Minnesota, the case law in the state of Minnesota, and based primarily on the video that was released by the civilian bystander who recorded the killing of George Floyd. The third thing that I would like to disclaim is that I don't, at this point in time, have any negative opinions about the charging decision that was made by, I believe his name is Mike Freeman, the Hennepin County attorney. Nor do I have any, ill feelings or opinions towards the Attorney General, Keith Ellison, who it's my understanding has now taken over the prosecution of Derek Chauvin in the killing of George Floyd. This video is intended to only represent my opinions, not the opinions of anybody who I'm affiliated with. And just my thoughts on the reasons why Derek Chauvin can be charged with first-degree, premeditated, intentional murder in the case of the killing of George Floyd. So this kind of breaks down into a few different sections. Before I even argue the facts based on the video, I want to make a couple of comments about two other things. So first, I'd like to talk a little bit about the role of the prosecutor and the role of the defense attorney when it comes to general criminal procedure. It is the prosecutor's job to bring the charges. I believe that prosecutors typically bring the highest charges they believe they have cause to bring. And it is the role of a defense attorney in order to attempt to introduce mitigating evidence or to further explain why a charge should be one way or the other. As a defense attorney, I very often make recommendations. The state might bring an armed robbery charge and I argue it down to a robbery. Or the state might bring a theft by taking charge and I order it down to a theft by receiving charge based on the evidence that comes out throughout the investigation. So my opinions as to the charges against Derek Chauvin are based primarily on the video that was released by the civilian who stood by and witnessed these events, and a little bit based on the complaint that was recently released. I believe that was on Friday that preceded a lot of the civil unrest and protests that we witnessed over the weekend. So first, my thoughts just about the role of the prosecutor and the role of the criminal defense attorney is that the prosecutor brings the charges, the defense attorney negotiates and might be able to convince a prosecutor to bring those charges down. I think that based on what we have kind of seen, and particularly the way that the complaint was written and released on Friday, it is one of the most defense-friendly complaints I have ever laid my eyes on. Very rarely do you see the facts of the case along with the mitigating evidence this early in the case. A prosecutor typically comes out very strong, very zealous in support of the charges that they bring. And the complaint, as it's been released at this point in time, offers some information for both sides. Now, I would never condone the hiding of defense-friendly evidence. That would be considered a constitutional violation to attempt to hide evidence. But it's just first and foremost very interesting to see the complaint as it was written at this point in time released, because it is quite defense-friendly. So that's just a little general statement about the role of the prosecutor to bring the charges, the role of the defense attorney to advocate for the client, to introduce mitigating evidence. And that's how the adversarial system tends to operate normally, which in high profile cases, there's definitely, a point to be made that it goes a little bit differently than your typical prosecution. So the second point that I want to make before I start arguing why Derek Chauvin could be charged with first-degree murder as we stand right now is a little bit about criminal procedure. Everybody has heard of beyond a reasonable doubt. And beyond a reasonable doubt, our constitutional rights require that the prosecutor prove a case beyond a reasonable doubt before our liberties can be restrained. However, that is the trial standard. What we are dealing with right now is very preliminary. This is an argument about what kind of charges could be brought and potentially what kind of charges could be indicted. Now, I can't go on without saying that, of course, even though Derek Chauvin is currently incarcerated or in pretrial custody based on a second-degree murder charge, those charges could be updated or upgraded, I should say, at the point of indictment. So just because there's a third-degree murder charge right now does not mean that a second-degree murder charge is not forthcoming, or even a first-degree murder charge. And the second biggest point when we're dealing with before we get to a jury trial is that all of these phases of criminal procedure are based on probable cause. Now, as a criminal defense attorney, I often have to explain to my clients when they're like, I didn't do this, I didn't do that, I didn't armed rob, I didn't have a gun, is that these charges are based on probable cause. Probable cause, typically when I'm explaining it to a layperson, is an incredibly low standard. It is some piece of information, some piece of evidence, or sufficient evidence to make somebody believe that you possibly have committed the crime that they have alleged, that they have information to believe that you've committed the crime that they have alleged. So at this point in time, and the reason why I chose my words very carefully, Derek Chauvin could be charged with first-degree murder does not necessarily mean that he could be convicted of first-degree murder. But considering the very skilled prosecutors that I have dealt with on day in and day out, and these typically are, depending on the case, you may be dealing with a newer prosecutor, typically when the charges aren't so serious, up to like a special prosecutor when the charges are more serious. In the state of Georgia, a lot of counties have a special prosecutor who deals with murders. They don't handle the thefts and the burglaries. It is a murder prosecution. It is a special prosecutor who does only murder cases. And so these are typically more experienced attorneys, more confident attorneys, more seasoned attorneys, ones who know how to look at and evaluate the evidence and say, here's what I believe I have probable cause for. They reevaluate it at the point of indictment and they say, here's what I still believe I have probable cause for. And they may even make a different charging decision. They can reduce charges, they can drop charges on the eve of trial before we go, when they are facing the burden, the ultimate burden, which is beyond a reasonable doubt. So from a criminal procedure standpoint, at this time, we are basing the charging decision, the prosecutor is basing the charging decision on probable cause. And based on the 9-minute video that had been released, I haven't been able to relocate that video. I'm not sure if the internet has pulled it down because it is so graphic, but I haven't been able to review the 8-minute video that I'm basing this opinion on, but I've seen it 3 or 4 times over the course of the last week. And based on that video, I believe a seasoned, high-level, experienced attorney could easily make probable cause for a first-degree murder charge. So now let's get to the interesting part, what everybody is here for. This is why I believe that Derek Chauvin should be charged with first-degree murder. I am not arguing. I'm simply explaining why I'm right. Okay, guys? So in the state of Minnesota, I have looked that up on my legal research tools. In the state of Minnesota, statute section 609.185 defines murder in the first degree as causing the death of a human being with premeditation and with intent to effect the death of the person or of another. That or of another is intended for transferred intent. It doesn't apply to this case. So what we're looking at is murder in the first degree is causing the death of a human being with premeditation and with the intent to effect the death of that person, of George Floyd. So what I have seen as far as the debate goes is that there are a lot of questions around premeditation and a lot of questions around intent. And the debate has gone, well, I don't know if we can show premeditation. I don't know if we can show intent. And so we're going with third degree depraved heart murder. But I've looked a little bit deeper into the case law surrounding the first degree murder statutes in Minnesota. And this is the reason why I believe that Derek Chauvin can be charged with the first degree murder of George Floyd. So under Minnesota law, you are allowed to look at a lot of things when you're determining premeditation. Actually, before I go there, a lot of people are saying that he can't be charged as being a premeditated killing because you can't prove that when he put his knee into George Floyd's neck that he had the intent or he had the premeditation to kill him at that point in time, which is a decent argument. And convincing a jury beyond a reasonable doubt about premeditation and about intent, which is things that exist in the minds of the defendant, is an incredibly difficult thing to do. And yet prosecutors do it every day across this country, in every state. They prove premeditation, they prove intent. If it was impossible, you wouldn't hear about these charges. But the fact of the matter is, it is possible to prove it as long as the circumstances warrant it. And to prove what's going on in somebody's head, you're allowed to use circumstantial evidence to show what was going on in his head at the same time. Here is where I would like to make a different argument than what I've been hearing online as it comes to premeditation. We don't have to prove that he premeditated George Floyd's murder when he put his knee into the back of his neck. I believe they can prove premeditation, or at minimum can argue premeditation based on the totality of the circumstances in the video. I cannot be the only person who watched that video and saw some kind of joy in what Derek Chauvin was doing to George Floyd. George Floyd was crying out for his mother, was telling the police that he could not breathe. And there is an instance in the video, and when I find it again and I can edit the clip and I can show you exactly what I'm talking about, there's a point in time where it almost seems like Derek Chauvin adjusted his weight, put some more weight into George Floyd's neck, and seemed very pleased at what he was doing. What my argument for first degree premeditated murder in this case is that in that instance, after he has heard this man say that he cannot breathe, that he's going to die, that Derek Chauvin dug his knee deeper into the neck of George Floyd. So if we separate those two actions, the act of placing the knee on George Floyd's neck and the act of putting more pressure onto George Floyd's neck, I believe the added pressure that Derek Chauvin placed on George Floyd's neck shows premeditation of his intent to kill. So under the Minnesota law, I've looked up a little bit of case law. Courts are to consider the defendant's actions following the killing when determining whether there was premeditation, which is a required element of first degree murder. For evidence to be sufficient of first degree murder, there must have been some appreciable time in order to consider, plan, or prepare for, or determine that they were committed to the killing. It can be inferred by a number of things. My focus is on evidence as to the nature of the killing, from which it can be inferred the killing was premeditated. My argument to everybody is that continuing to apply pressure, or even applying increased pressure on the neck of George Floyd after a man has said that he cannot breathe and that you are killing me, is an act in and of itself that shows premeditation. Further, the second element, on top of premeditation, we have to argue the intent to kill, which is something that has been highly debated from everything that I've seen on social media about whether someone could prove or has any evidence to show that Derek Chauvin also not only premeditated, but intended to kill George Floyd. So here's the case law that I pulled out as most relevant when it comes to Derek Chauvin's intent to kill George Floyd. Leaving an incapacitated victim to die supports an inference of an intent to kill. That is a 2009 case out of Minnesota. And the defendant's conduct after the killing can be relevant to his or her intent to kill. That's a case from 1996 out of Minnesota. I think that it is not only arguable, but that a jury could be convinced that Derek Chauvin intended to kill George Floyd based on the totality of circumstances in the video. When this, I think my analysis would follow that the fact that he kept his knee in George Floyd's neck for, I think they said 2.5 to 3 minutes after George Floyd lost consciousness. These facts are not only evidence of premeditation, but also of his intent in the killing of George Floyd. And then I got a question when I posted that I'm sorry, I keep mixing up the names, that Derek Chauvin intended to kill, premeditated the killing of George Floyd. One of my friends on Facebook did ask, what about lesser included offenses? It's been in my experience as a criminal defense attorney, and I'm sure I am not alone in this experience, that prosecutors will bring the highest charge they can bring, leading up to trial and even into trial, understanding the way that the laws of lesser included offenses play out. So in the state of Minnesota, it's very much like my understanding in the state of Georgia. If there is evidence of a lesser included crime, a defendant may be entitled to an instruction on a lesser included crime. It's typically used as a defense strategy in order to get you off of, first degree premeditated intent to kill murder, which calls for life imprisonment if you're convicted, where you can introduce the lesser included if the facts call for it, to argue for second degree murder or even third degree murder in this case. And the case law follows in Minnesota that the prosecution or the defense can ask for that lesser included charge. Not only can they ask for that lesser included charge, I would have to delve a little bit deeper into Minnesota law, but I've seen indictments that come with first degree, second degree, third degree murder all on there. Let the jury decide which charge they would like to convict for. Now, of course, there are competing philosophies about whether you should do that. But the question that I'm trying to answer today is whether he can be charged with first degree murder. And based on everything that I've read on the Minnesota law, and based on what I have seen in the 9-minute video, the civilian shot video of the death of George Floyd, and it has not been refuted by anything that I've seen in the complaint, in the closed caption TV footage that was released from the store. I've seen some of the body worn footage from the police officers who responded to that scene. I have not seen anything that has changed my mind about the fact that Derek Chauvin can be charged in the death of George Floyd to the maximum extent of the law, which would be first degree premeditated intentional murder. So to close this out with my disclaimers one more time, I am a Georgia licensed attorney. I am not a Minnesota licensed attorney. I don't have anything against AG Keith Ellison, who is, I believe, currently prosecuting the case. I have nothing against Mike Freeman, the Hennepin County attorney who was previously involved in the prosecution of the case. But it is my belief, I've seen enough videos, I've seen this video enough to believe that you could arguably charge Derek Chauvin with the murder of George Floyd. It's for another day for us to discuss charging decisions and how that is a power play in the negotiation. I'm very concerned that bringing the charges as they've been brought right now, that Derek Chauvin's going to be afforded the opportunity to plea out to the manslaughter charge, which carries very minimal time. And even if he pled out to the third-degree murder charge at this point in time, there is no mandatory minimum in that case. There is nothing that would keep the prosecutor from making a deal that says he gets straight probation. I would like to see the prosecutors bring a higher charge. I would like to see them put Derek Chauvin's feet to the fire the same way that I've seen so many of my clients charged with cases with facts that may support probable cause for the charge, but may never be supported by proof beyond a reasonable doubt. And they do that strategically to gain the position. The way they're positioning right now, I'm concerned we're going to see probation in this case. So, like I said, I'm not arguing. I'm simply explaining why I'm right. Derek Chauvin should be charged with first-degree murder in the killing of George Floyd. Thanks for listening.